Thanks very much, and thanks to everyone for joining us this afternoon. I'm a partner in Mayor Brown's Washington, D.C. office and a member of our firm's Supreme Court and Appellate Practice Group. In that connection, I brief and argue cases in the Supreme Court and other federal courts, and filed an amicus brief in the HALO case on behalf of BSA, the Software Alliance, although, of course, the views that we'll express today are not attributable to them. Joining me today as a co-presenter is Brian Rosenthal, who's a partner in our New York office, a member of our intellectual property practice, who specializes in patent litigation, licensing, and counseling, focusing especially on litigation involving computer software, electronics, and medical devices. Before we begin, a couple of housekeeping announcements. Please ask questions as we go along. The worst thing for any litigator is to just talk and hear themselves talk, so please ask questions, and we'll endeavor to answer as many as we can. You do that if you look at your screen. There's on the lower right, there's a Q&A section. You can type in your question and hit return, and then it will be visible on our screens, and we will endeavor to answer them. If we don't answer your questions during the presentation, we'll follow up with you afterward. Second, regarding the all-important CLE credit, we will be providing the magic alphanumeric code during the presentation. To receive your CLE credit, you have to record that code on the virtual sign-in sheet that was emailed to you with the login instructions for today's program. So please listen for that code, and we'll repeat it several times. Finally, just to reiterate, the views that Brian and I express today are our own and should not be attributed to our firm or to our clients. With that, let's get started. Just a little bit of a roadmap to the issues that we're going to focus on. Obviously, we want to spend time talking about the state of the law prior to HALO and what HALO says about its new standard for finding willfulness and therefore awarding enhanced damages in patent cases. We'll talk a little bit about what the results might be. Are there going to be more awards of enhanced damages, fewer, different cases, maybe a little bit of both? Obviously, that's something that's going to be a hot topic of conversation among the patent bar and a hot topic of litigation in the lower courts. HALO didn't just address the substantive standard for willfulness. It also addressed burden of proof and the standard for appellate review, so we want to talk about that. And then we want to switch focus and talk about the practical implications. What does this mean for litigation strategy and settlement dynamics? What does it mean for pending cases that may have been decided by a district court under the Seagate Standard? And what does it mean for the practice of obtaining opinions of counsel and waiving privilege with respect to those that was such a hallmark of the pre-HALO and especially the pre-Seagate practice? So with that, let's get started. And of course, the starting point, as the Supreme Court reminds us constantly in statutory interpretation cases, is the statutory text. Section 284 is the operative provision, as I'm sure everyone on the call knows. And the critical language there appears in the middle of the paragraph discussing the standards for awarding damages in infringement actions, and it's a pretty simple paragraph, pretty simple sentence. It says the court may increase the damages up to 3 times the amount found or assessed. And then there's a limitation on the availability of damages in provisional rights cases. So that's the sum total of the congressional authorization. A little bit of history, I think, is important in understanding what the Supreme Court was confronting and what its decision might mean. A good starting point is the underwater devices cases that the Federal Circuit decided in 1983. And there, as people who have been practicing in this area remember, the court adopted a quite broad standard for the availability of enhanced damages, which you see on the screen, saying there was an affirmative duty to exercise due care when there's actual notice of another's patent rights. And that, as time went on and patent litigation especially heated up in the late 90s and early 2000s, that standard was severely criticized for opening the door to enhanced damages based on a demand letter and then allegations of inadequate investigation and a real fear that the demand letter itself would trip a process that could lead to the enhanced damages claim getting to the jury. As a result of that, the practice of obtaining opinion letters developed on the theory that that could show that there was an adequate investigation and therefore enhanced damages weren't justified. But the criticism of underwater devices continued, and as a result, the Federal Circuit in 2007 adopted a different test, the Seagate Technology test. And as I'm sure people know, but just to remind, it was a two-part test. It had an objective component and a subjective component. So the first element, the patentee had to show by clear and convincing evidence that the infringer acted despite an objectively high likelihood that its actions constituted infringement. And that test is irrelevant to consider state of mind. The focus was the record in the infringement proceeding, and an objectively reasonable defense to infringement could suffice even if the accused infringer was unaware of that defense at the time of the alleged infringement. So that's the objective reasonableness element. And the second, the patentee had to show by clear and convincing evidence the risk of infringement was either known or so obvious that it should have been known to the alleged infringer. When both steps were satisfied, in other words, this is an and, not an or, the district court could proceed to consider whether to exercise its discretion to award enhanced damages. Then subsequently, the Federal Circuit made clear that the objective recklessness question was one of law to be considered by the judge, not the jury, and it was subject to de novo review on appeal. So the combination of the substantive standard and those procedural elements obviously tightened significantly the standards for awarding enhanced damages and made enhanced damages rarer and more difficult to obtain. A little bit of a slide about what was going on. As a result of Seagate, many defendants sought and courts granted summary judgment on non-willfulness. The objective reasonableness prong in particular was suitable for summary judgment in many courts' view. And I'm not going to get into the details. We just picked these two cases as an example, but as I'm sure the practitioners on the phone know, that was a frequent focus of defendants trying to eliminate an enhanced damages claim, and showing objective unreasonableness was a very important hurdle for plaintiffs to overcome. The Supreme Court granted review in two cases. Halo ended up being the principal case in which the decision was made, but both cases really posed for the court the question whether the Seagate Standard, as it had been elaborated in subsequent cases, was a correct statement of the law. Halo, and these cases to some extent were paradigmatic infringement actions, one in which, as you see on the screen, the district court had held infringement was not willful, and the Federal Circuit affirmed a case arising in the context of electronics. And the second case, Stryker, arising in the medical device context, where the jury had awarded enhanced damages based on a significant jury award. I believe it was $70 million for regular damages, and the Federal Circuit held that enhanced damages were not appropriate under Seagate. So the question before the Supreme Court was really, is this Seagate Standard an appropriate statement of the law? And although the Supreme Court said some nice things about Seagate, as I'm sure folks know who have signed up for this call, it rejected the Seagate Standard. The court said what Seagate got right was a recognition that enhanced damages are generally appropriate only in egregious cases, and this word egregious appears several times throughout the opinion and is clearly, in the court's view, an important fulcrum for what the test is. But the court said the Seagate Standard was unduly rigid by requiring proof of objective recklessness. I'm sorry, that should be objective unreasonableness in every case. And the court focused on a specific example of why the objective unreasonableness test didn't necessarily work. It said because you could have a situation where someone was a wanton pirate, an actual intentional copier, who didn't care about validity, didn't care about any notion of a defense to infringement, was setting out intentionally to steal the patentee's business, but the defendant could come up with some defense later, as the case was litigated, that might prevent the showing of objective unreasonableness. And the court said clearly that wanton and malicious pirate situation was one where enhanced damages should be available, and if the objective reasonableness prong of Seagate was going to preclude an award of enhanced damages in that context, and the court said it would, the court said that means that the standard couldn't possibly be right. But the court said that doesn't mean that we're going to adopt a rule that says anything goes. District courts have total discretion to look at all the facts and circumstances and decide whether enhanced damages are appropriate. And here's some critical language, I think, in the court's opinion that's based on its prior cases in which enhanced damages were upheld. So not to be meted out in a typical infringement case, but are instead designed as a punitive or vindictive sanction for egregious infringement behavior. The sort of conduct warranting enhanced damage has been variously described in our cases as willful, wanton, malicious, bad faith, deliberate, consciously wrongful, flagrant, or indeed characteristic of a pirate. So I think that sentence and that compilation of adjectives was really designed to, or adverbs, I guess, really designed to make clear that the court, although it was overturning the Seagate rule, was saying that its prior decisions set out a pretty high standard for the kind of wrongdoing that has to be shown in order to award enhanced damages. Conduct characteristic of a pirate is a pretty tough test. So the court, in sort of explaining how it got to its rationale, looking back to the statutory text that we started with and saying this text grants broad discretion. In fact, the text doesn't have any test at all for when enhanced damages are appropriate. But the court said in the 2 centuries that enhanced damages have been available, nearly 2 centuries, that channel of discretion provided by the statute has been narrowed, so that damages are generally reserved for egregious cases of culpable behavior. Again, I think that phrase, egregious cases of culpable behavior, combined with the language that we just discussed, shows you that the court is again underlining the idea that its standard is going to require some severe wrongdoing in order to permit enhanced damages to be awarded. And just to confirm that, the court later again in its opinion says, enhanced damages are not available in garden variety cases of infringement. The principles that the court has laid out in this and prior opinions channel the district court's exercise of discretion, limiting the award of enhanced damages to egregious cases of misconduct beyond typical infringement. So again, you see that word egregiousness occurring once again to say, I think to signal, we want some really severe wrongdoing here. Now, one important point that the court made in distinguishing its test from the Seagate test was to say that culpability is measured by the knowledge of the defendant at the time of the challenged conduct. So defenses that are developed after infringement are not going to be relevant in insulating that conduct from an award of enhanced damages if they were something of which the defendant was entirely unaware at the time the challenged conduct was taking place. So this again harkens back to the reason that the court rejected the 2-part Seagate standard, saying that it just couldn't be that someone who sets out to be a pirate totally disregarding the patent law and the limitations that it imposes is not going to be saved because they happen to have a good lawyer who later develops a defense that shows that there was a reasonable, there would have been a basis for a reasonable belief that the conduct wasn't infringing if that was something that was totally unknown to the plaintiff, to the defendant at the time. So I think it's important to recognize that the court isn't saying that not knowing that defense is necessarily produces liability. The court's focus here, as in the prior passage about pirates, is to say we're not going to let people who have set out intentionally to violate the law to be saved because their lawyer finds a clever legal argument later in the game. We're really going to focus on what they were thinking and what they knew at the time of the challenged conduct itself, if, of course, that conduct turns out to be infringing, which is the predicate for awarding enhanced damages in the first place. The other thing the court pointed out is that even when egregious misconduct is found, the district court doesn't necessarily have to award damages and doesn't necessarily have to award the full amount of enhanced damages. Rather, it has discretion and can take into account all of the facts and circumstances of a case in deciding whether to award enhanced damages even when egregious misconduct is shown, and in deciding how much any award of enhanced damages should be. Now, the opinion that I've described was unanimous, joined by all the justices, but three justices, Justices Breyer, Kennedy, and Alito, joined an opinion by Justice Breyer that further drilled down into their views on what the court's, the standard in the unanimous decision meant in particular cases. And I think these names will be familiar, particularly Justice Breyer and Justice Kennedy, to followers of patent decisions as justices who have sometimes worried that about the need to balance patent liability with a recognition that sometimes overexpansive liability can deter innovation as much as too great a limitation on infringement liability could eliminate the proper incentives for innovation. So it's not surprising, perhaps, that these justices focused on 3 points to make clear, underline, if you will, situations in which they thought enhanced damages were not appropriate. First, Justice Breyer, who wrote this opinion, says enhanced damages are not appropriate if the infringer knew about the patent and nothing more. Obviously, there had been briefing, particularly in the amicus briefs, about the demand letter situation, and I think Justice Breyer was reflecting concern that no one interprets the court's opinion as saying a demand letter, proceeding in the face of a demand letter is enough. So he wants to make clear that a demand letter or knowledge of the patent is not enough. Rather, there have to be circumstances that transform that simple knowledge into, and again we see this word, egregious behavior, and that makes all the difference, he says. And he then says those circumstances are ones that show the defendant's conduct to be deliberate or wanton, akin to the wanton and malicious pirate that featured in the court's opinion. Second, they point out that the decision doesn't weaken Section 298 of the American Inventor Act, which provides that failure to obtain advice of counsel may not be used to show willful infringement. And then finally, and I know Brian is going to talk more about the advice of counsel question under this new standard. And the third thing they say is enhanced damages cannot be justified to compensate for damages or litigation costs. In some early opinions, there were some indication that enhanced damages could be justified, for example, where attorney's fees were large or there were other litigation costs. But of course, the subsequent addition of a provision for attorney's fees in the Patent Act obviates that. And there was some litigation, some discussion in the amicus briefs in this case about whether these enhanced damages were akin to sort of super punitive damages for wrongful conduct, or whether they could be justified on these other grounds. And I think Justice Breyer here is just underlining his view that they can't be justified on those grounds. I think stepping back a little bit and trying to, again, give some more perspective to what the court decided and what its decision really means, we looked at the beginning to the legal context in terms of the run-up to the court's decision. I don't think anyone would say that this is a reinvigoration of the underwater devices standard. The use of egregiousness and the court's references to willfulness multiple times and to wanton misconduct certainly indicate that it's thinking about a much higher degree of wrongfulness. The court certainly rejected the Seagate Standard, but what were the other arguments that were floating around in the case? And I think it's instructive to look at what some of the parties and the U.S. government, who's obviously the most important amicus, were arguing. Obviously, the defendants were supporting Seagate, but where were the plaintiffs? HALO filed a brief saying, you know, look at all relevant factors, essentially. A look at all the factors test and apply discretion to decide whether, based on those factors, enhanced damages are appropriate. So a test that really would have given very significant discretion to the district court. The brief fleshed that out by talking about some situations in which enhanced damages might be appropriate, bad faith infringement, unnecessary expense and burden on the patent holder, purposely ignoring the patentee's license attempts, and failing to investigate. So that standard, if it had been adopted, I think, obviously would have been much closer to underwater devices, or to what the court said about the award in attorney's fees in the Octane Fitness case, that it was really a look at all the facts and circumstances to decide whether something is exceptional. Stryker similarly had a totality of the circumstances argument and said heightened culpability is necessary, but its definition of heightened culpability was anything more than negligence. And certainly the language of the court's opinion does not seem to have gone down that road, because the use of egregiousness and wanton and willful certainly seems to indicate a mental state that's much more demanding than just more than negligence. Finally, the government, maybe most closest to where the court ended up, talked about deliberate copying as the paradigmatic case for enhanced damages, but said it wasn't required that bad faith or reckless conduct could justify an award of damages. I think if you look at these submissions, it's striking that the language that the court used in describing its test was on the much more demanding end of the scale than what the plaintiffs were urging it to do, and also somewhat more demanding, at least, than the United States, since there doesn't seem to be any indication in the opinion that reckless misconduct is enough. So I think looking at the arguments confirms the idea that the court's own language viewed alone points to, which is this is a different test, certainly, than Seagate, but it's not at all a test that opens the door widely to enhanced damages in lots of cases. The court is demanding a pretty tough level of culpability before that's going to be permissible. I think it's also interesting to ask, okay, objective unreasonableness or objective reasonableness is no longer a defense. Under Seagate, of course, if you showed objective reasonableness, the enhanced damages claim went away. That's no longer true. Does that mean that objective reasonableness is irrelevant? The court certainly doesn't say that in its decision, and certainly one would think that if at the time of the alleged infringement, the defendant knew the facts that are the basis for the finding of objective reasonableness, that would go a very long way to negating the kind of heightened culpability that the court seems to be requiring. So it seems as if objective reasonableness may be tweaked to say that what's relevant is what the defendant knew at the time, still seems to be relevant. And there's a decision today that the court handed down in a copyright case that seems to provide some support for that. The Kurtzing case, just to take a little detour, is the second round of the Kurtzing case that was before the court a couple of years ago dealing with international exhaustion. Here the question was attorney's fees. And the court said that in deciding whether an award of attorney's fees under the Copyright Act is appropriate, whether the losing party's position was objectively unreasonable is a significant, although not a dispositive factor. You still have to look at everything else, but that objective unreasonableness is still a significant factor that deserves significant weight. Obviously, that's attorney's fees. How do we get from Copyright Act attorney's fees to enhanced damages under the Patent Act? It's really two steps. Folks will remember the Octane Fitness case interpreting the Patent Act attorney's fees provision relied significantly on the interpretation of the parallel provision in the Copyright Act. And the HALO decision earlier this week relies on Octane, saying that part of what the Federal Circuit error was in Octane was creating a very strict structure for imposing liability for attorney's fees that wasn't justified by the statute. And here, too, the court, citing its Octane Fitness decision, said that was a problem with Seagate. But I think that linkage may be used certainly by defendants to say not only did the HALO court not reject objective reasonableness as something highly relevant in rebutting claims of for enhanced damages, but this sort of parallel interpretations of the Copyright Act provides additional support for that conclusion. In addition to the new substantive standard, HALO adopts some new procedural rules. Recall that as it has in other circumstances, notably in the attorney's fees circumstance where those rules were rejected in Highmark, the Seagate required clear and convincing evidence. HALO rejects that and says it's a preponderance of the evidence standard. There's no basis in the statute for applying a higher standard of proof. The Federal Circuit had adopted a tripartite standard for appellate review, the objective reasonableness test reviewed de novo, subjective knowledge under substantial evidence, and whether to award enhanced damages for abuse of discretion. The Supreme Court said, again, nothing in the statute that indicates that kind of deviation from the ordinary rules of appellate review, because 284 commits the determination of whether to award enhanced damages to the discretion of the district court. The decision is reviewable for abuse of discretion. Of course, abuse of discretion means that the district court gets some leeway when it acts within legal boundaries. But the court made clear in this part of the opinion the substantive standards that it had set for the award of enhanced damages limit that discretion. And so if a district court awards enhanced damages in circumstances that are outside that legal standard that the court set, that's something that can be reversed on appeal. One thing the court did not address that has been an issue that was raised in some of the briefing is who decides these questions of whether enhanced damages are appropriate and what the amount should be. Is that a decision for the jury, for the judge? Not addressed, and certainly something that I think is going to be a topic of litigation in the future. So just to sum up, before I hand off to Brian to be the prognosticator about what all this might mean in the real world of litigation, there's obviously going to be a coming battle over what HALO means. Is it a broader opening for enhanced damages or just a different test that focuses more on sort of level of culpability but establishes a high level of culpability? So does that mean a greater focus on subjective intent and an attempt to prove copying that sort of fits the case into the paradigmatic example of the pirate that the court and the concurrence talk about? Where will the level of intent be set? What's the court going to do in terms of setting that meter? What will the Federal Circuit say about willfulness, knowledge? My guess is that plaintiffs will try to argue that knowledge plus proceeding to copy may be enough. Knowledge not just of the patent, as Justice Breyer said, but perhaps some knowledge of some level of risk that the conduct is infringing. On the other hand, defendants can be expected to say egregious conduct means egregious. This has to be somebody who really sets out to do wrong in order for enhanced damages to be applied. And as I just was talking about, what will the relevance be of objective reasonableness? Will that be something that defendants will, particularly at the summary judgment stage, still advance and say, if we can show objective reasonableness, the plaintiff has to come forward with a pretty powerful evidence of egregious wanton culpability in order to have a claim that still makes sense to go to the jury? And what will district courts do about that kind of argument? Will they say, oh yes, that's fine, we're still going to look to grant summary judgment on these claims, or will a new standard mean a significant reduction in the resolution of these claims before trial? So, Brian?
Thank you, Andy. You'll notice that in the last slide that Andy presented, there were a lot of question marks, and I wish I could say that I had answers to all those questions, but I don't. The Supreme Court really has left the application of this standard, as it sometimes does, to the district courts and the Federal Circuit to figure out what it all means. As Andy mentioned, the next couple years of litigation in the district courts and the Federal Circuit is going to flesh all of this out. But in the meantime, those people that are litigating cases are going to have to deal with this issue before it is fully fleshed out. And indeed, the cases that deal with this issue are going to shape this law into what it will ultimately be. One of the first practical considerations is, what does this mean with respect to pretrial motions like summary judgment? As Andy mentioned, it has become almost routine in patent cases where willfulness is alleged to file a motion for summary judgment of non-infringement. Not all district courts are entertaining these motions seriously, but a lot of them are. And depending on the jurisdiction, it is almost, let me put it this way, the bar is not terribly high to obtain summary judgment of no willfulness. Many courts will say, if you have articulated, even before I hear a full presentation of all of the facts and arguments at trial, if you have articulated a reasonable basis to defend the claim, invalidity, claim construction, non-infringement, or otherwise, that's enough for me to determine that there's no objective recklessness. I don't have to get into at all of the subjective intent questions. What this means from a practical standpoint is that often a patent holder will have a whole story that they want to tell about knowledge of the patent and bad acts of the accused infringer, and courts are taking that right off the table with summary judgment. Now the question is a lot trickier. This new standard may make summary judgment more difficult to obtain. It's not entirely clear whether it will. I tend to think that it will, but it's certainly possible that district courts will look at the facts and look at for instance, the existence of opinions of counsel whose arguments align closely with those arguments raised at trial, certainly the absence of certain facts, and district courts may, at a summary judgment stage, determine that there are not any facts in dispute that would change my mind as to whether to exercise my discretion, and therefore I'm going to grant summary judgment of no willfulness. Certainly a possibility. The first cases that look at that question will be very telling. So the question that comes to mind, this first sub-bullet, is will district courts grant a motion for no willfulness without having a fact finding into egregious conduct? For instance, at what point in time did the accused infringer know of the patent? What steps did they take? Did they get an opinion of counsel? What does that opinion of counsel say? Are there facts of copying? What did they believe at the time, despite what the opinion of counsel might or might not say? Will a district court at a summary judgment stage be able to rule on a summary judgment motion? The framework that exists today allows the district court to do that very easily by simply saying all of that subjective information is absolutely irrelevant to the first prong, and I can decide it on the first prong. Now that we have a much more amorphous and certainly unitary test that puts everything together, that may be more difficult. The second question that this raises is if there has to be a fact finding about the underlying facts surrounding the alleged egregious misconduct, who makes those factual determinations? I'm going to get into that question a little bit more in the next slide. But will district courts allow juries to hear all of the egregious conduct facts and reserve a willfulness determination until after the jury renders its verdict? I'm sure that many courts will. That I think we can be pretty comfortable in saying, that certain courts will say, I want the jury to render its verdict on all of the issues, and the jury should hear all of the facts related to quote-unquote willfulness. And after all of that evidence goes in, and I hear the jury's verdict, I'll make my determination with respect to the discretionary willfulness finding. But there may be other courts who say, since ultimately this issue is mine to decide on discretionary grounds, and because the facts surrounding willfulness may not have applicability to any issue that the jury actually needs to hear and decide, I'm not going to let the jury hear those facts because I don't need to in order to render my decision. The questions that all of these that are on the slide here are really left to the district courts and to the Federal Circuit to answer. And so those who are facing willfulness allegations, or who are making willfulness allegations in cases now, are going to have some arguing to do to try to convince district courts which way they ought to handle this. There is, I would say, precious little guidance in the Supreme Court decision. If we go to the next slide, related to that question is the question of bifurcation or staging trials. This is another very practical consideration. Traditionally, there have always been arguments about cases that do go to trial, whether or not damages and willfulness ought to be bifurcated from liability. There's lots of good reasons to do so, since patent infringement is a strict liability offense, at least with respect to direct infringement. There's a lot of reasons that people will bring to bear to argue that the jury should not hear the facts surrounding willfulness and not hear the facts surrounding damages during liability, because it will infect their determination of the liability issues. Not all judges agree with that, and not all cases are bifurcated in that way. Many are not. That question will be raised in a new light now. Accused infringers are very likely, if they don't get summary judgment of no willfulness, they're very likely to ask the court, well, you ought to at least stage the trial, since willfulness is so soundly now within your discretion. The best way to handle that question is to first allow the jury to render its verdict on liability, and only after that, and maybe after a finding on damages, hear the willfulness or egregious conduct facts. Another approach that litigants might seek, and this bears on the question of whether, or depends on the question of whether there's a right to a jury trial on the issues underlying egregious misconduct, is litigants might seek an additional evidentiary hearing before the court outside the presence of the jury as part of post-trial motions, like exceptional case awards are handled. The Supreme Court drew the parallel between the octane fitness standard and the standard that it was adopting in the HALO decision. So there's certainly some consistency to the notion that since the Supreme Court is really treating these two enhanced and exceptional case standards very similarly, why not handle those procedurally in a very similar manner? And after the jury renders its verdict, and the court is considering that verdict, at that point in time, the parties can brief the questions of exceptional case, and they can enhance damages. And as part of the enhanced damages briefing, there may be a need for an additional evidentiary hearing that only the judge needs to hear. These are the sorts of kind of creative ways of handling this question that I expect you're going to see litigants urging the court to adopt. On the other hand, patent holders are going to look at this and say, well, it's made very clear from the Supreme Court that subjective willfulness of a patent infringement, the intentionality, the wantonness of the accused patent infringer are facts that need to be or should be taken into account when determining whether or not to exercise the court's discretion. And there's certainly an argument that the litigants and the patent holder in particular has a right to a jury trial on those factual issues that underlie the finding of egregious misconduct. So this is going to be a big battleground. And I expect that we're going to see very, very different approaches among the district courts. And it could be like the Federal Circuit ultimately did in the Bard versus Gore decision a couple years ago, when it held that the objective standard was a matter for the court. It could be that after a year or two of the district courts coming up with different approaches, that the Federal Circuit really lays down a workable and predictable procedural mechanism to deal with these questions. But until that happens, it's really greenfield, and it's going to be a matter of which judge you have and their willingness to experiment with different ways of handling this. But there's certainly arguments to handle this in a lot of different ways. If we go to the next slide, a very important question that's going to come up immediately in cases is, what is the effect of this case on settlement? And hand in hand with that is leverage. Because of the uncertainty that I just described and that Andy's been talking about with all these questions, how are district courts going to procedurally implement this? How often will they grant willfulness? How often will they exercise their discretion? Will they see this standard as a more restrictive standard, even if handled in a different context? Is it more or less restrictive is a question that's really unanswered. There's a lot of uncertainty. And as a result of that uncertainty, patent holders may well see this as an opportunity to generate more settlement leverage. So first of all, because summary judgment may be more difficult to obtain, a patent holder might, in settlement discussions, mediation, et cetera, might take the view and argue, we're going to be able to present our willfulness case to the jury. There's no out for you. You're not going to be able to obtain summary judgment like you might have been able to before, and therefore the chance of us winning goes up because we're going to be able to tell a much different story. Not only does the chance of us winning go up, but the chance of us winning enhanced damages also goes up as a result of that. And on the other hand, defendants will probably try to spin this to say you've got a higher standard, making it less likely that judges will enhance damages, and maybe even argue, look, as far as we can tell, this decision says it's soundly within the discretion of the trial court and does not need the jury to address the underlying factual questions. So there's going to be a lot of jockeying in settlement discussions about what it means and how it's going to affect the ultimate presentation of evidence before the jury and the outcome. Another consideration is that, and this was addressed in the concurrence, is that because of the uncertainty in the standard, as it exists now and maybe even as it develops, because it's so soundly within the trial court's discretion and almost I know it when I see it sort of a standard, we may see an increased number of cases filed. There could be cases that are shaky, that are not being filed now because of all kinds of reasons with octane fitness and all of the other impediments to patent holders filing cases. There's no question that this decision will be viewed by many potential plaintiffs as shifting the balance towards patent plaintiffs again. And when people are making their determinations, if they've got a story that they can tell on the egregious misconduct front, even if the merits of their case isn't all that strong, it might incentivize them to bring the case up. So especially where there's a history between the two parties, this gives, I think, an incentive to litigants, to patent holders, to file a suit that they might not otherwise have filed. In short, this case really puts willfulness back into the conversation. Today, when you're having settlement discussions with someone over a seriously disputed case, the question of willfulness, at least in my experience, it just doesn't come up all that often because of the fact that, number one, you have this great mechanism from the defendant's standpoint to exclude willfulness from the case via summary judgment, and also just because of the empirical evidence that willfulness just isn't found nearly as much as it used to be, and the judges aren't increasing the awards as much as they used to, despite a few recent cases otherwise. That conversation is going to change. Now willfulness will be part of the conversation. People are going to be jockeying, especially in the early days, to try to use this case one way or another. I think on balance, it's fair to say that it sure looks a little bit more pro-patent holder than it does pro-accused infringer on first glance. It remains to be seen how it will be applied, but it certainly seems like it'll be spun that way more often. If we go to the next slide, another question is what happens with respect to pending cases? This is a sort of a practical consideration for cases where there's already been a finding of summary judgment of no willfulness, or there's already been a jury finding of willfulness or no willfulness. Question now becomes what happens to those cases in view of this standard? Obviously, some cases may have been put on hold, or this issue may have been put on hold, and for those cases, there isn't, that just reverts to the previous slides that we had, which is how does the judge handle that. But in cases where there's already been a determination, expect to see a lot of motions for reconsideration and retrial. Where there's been summary judgment of no willfulness, it's very likely we're going to see motions for reconsiderations. It'll be very, very telling to see whether district courts grant those motions again. For the reasons that we've discussed, they could say, look, I have seen the evidence of the objective reasonableness of these defenses. I've seen evidence that objectively reasonable defense was within the knowledge of the accused infringer at the time. And that's enough for me to say I'm not going to exercise my discretion and grant willfulness in this case. That's certainly possible. I think more likely we're going to see at least some district courts grant that motion for reconsideration, deny the motion for summary judgment, and then there's going to, or I should say, deny the motion that they previously granted, and then have some kind of a fact-finding, and then that reverts to how that fact-finding happens. So there is the potential for the undoing of some of the decisions that have already happened in some of these cases. And similarly, it should come as no surprise that if there is a jury finding in either direction under the old standard, it's likely that you're going to see motions to set aside jury verdicts and for new jury trials on this issue. So for any litigants who are in the position of already having a quote-unquote settled issue of willfulness, it's likely to become unsettled in the near future. And we'll go to the next slide. And this is the last slide that we have, and this is the question of opinion of counsel. those that have been practicing for a while know that, especially those that are in-house, the question of whether to obtain an opinion of counsel and the question of whether to waive privilege over that opinion of counsel are questions that are constantly being addressed for all kinds of reasons. There's cost issues associated with obtaining opinions every time you get a demand letter, especially for those that get a lot of demand letters. And then there's the question of whether you waive. And when you waive advice of counsel in the middle of a litigation on an opinion, a lot of stuff comes with that. There may be things in the opinion that are inconsistent with the positions that you're taking at trial. There may be huge discovery issues and costs associated with it. The scope of the waiver is often in dispute despite guidance from the courts. And so there are a lot of reasons to waive, and there are a lot of reasons not to waive. When Seagate came around, and even more so when Bard versus Gore was decided, but once Seagate established this objective test that must be satisfied first, it tipped the scales against the need to obtain opinions of counsel and against the need to waive attorney-client privilege. And some companies made the decision, or I should say lowered the threshold, or maybe the better way to say it is raise the threshold for when it's necessary to get an opinion of counsel. In short, companies were obtaining opinions of counsel less often. And similarly, they were waiving advice of counsel and privilege less often. The reason is they could count on, much more so, the possibility of getting rid of willfulness on the subjective prong. The question is now going to become, is that really the right decision now? It's still the case, Section 298 of the Code is still there, that the failure to obtain an opinion of counsel will not be held against you as a matter of a presumption or an adverse inference, but there's still a stronger incentive to obtain opinions. There's still a stronger incentive to waive privilege under the new rule. And the reason for that is because this is within the court's discretion, because you no longer have the out of an objective test, and because the decision of whether to waive advice of counsel has to be made very often in the middle of discovery, long before these issues are resolved by the court, it will often be the case that companies say, I'd rather play it safe than sorry, I'm going to waive advice privilege and rely on my opinions of counsel in order to help the judge exercise his or her discretion in my favor. So I think on balance, there's probably more of a reason to get opinions. There's more of a reason to waive on opinions. And I think we're going to see more of that swinging the pendulum back from how it has been over the last 10 years.
Thanks, Brian. That's the end of our presentation, and it's 3:30 Eastern, and we're at the end. If you have any questions, please feel free to email either Brian or me. We'd be very happy to answer them. Thanks very much for joining our call, and have a good day. Bye-bye.
Thank you. Bye-bye.